A partition action allows a co-owner of a property to force a sale of that property so that they can take their share of the proceeds. However, in some cases, the other co-owners may not want to sell the property. While it's very difficult legally to stop a partition action, there are alternatives. What is a partition action in real estate? Commonly, a partition action occurs when a single-family home has been left to children in a family trust or estate, and one of the children wants to sell their share to get their share of the proceeds. It's each child's right to sell their share anytime they choose. However, because a single-family home cannot be divided, per se, the result of the partition action is that the home will be put up for sale on the open market, and when sold, each of the children receive their fair share. However, if one of the children wants to keep the family home, then what? Well, they can negotiate to purchase out the other children's interests. But if the home's value cannot be agreed upon, then frequently the co-owner who wishes to sell will need to file a partition action, forcing the sales home so they can get their money. Can a partition action be stopped? In most cases, a partition action cannot be stopped. However, there may be some legal defenses that can prevent or slow a forced sale. The first is a contractual agreement. If the property is purchased by co-owners, a contract may exist that indicates a partition action cannot be filed or can only be filed under certain terms. The agreement might also say that the partition action needs to be filed within a certain time frame, or that mediation or arbitration are required prior to going to court. A second option is selling your share to other co-owners. A trust litigation attorney can help negotiate a sale of one co-owner's share to another owner, and if a settlement cannot be negotiated, then perhaps settlement through a mandatory settlement conference or mediation is a next step. Third, you can sell your share for the most money. A trust litigation attorney can help ensure that the property is sold for the most money possible so that you get the most out of what your share is worth. Fourth, you can secure a buyout of your co-owner's shares. Sometimes clients don't want to own an inherited property with their other family members and think first only of selling their interest to get out. But often it's possible to buy out your family members and retain the property, even if only for as long as you need to rehabilitate the property before reselling it. Fifth, the partition actions and spouses. Depending on when the property was purchased, a spouse may or may not have the right to file for a partition action. If you are involved in a marital dissolution proceeding, we can work with your divorce attorney to determine what rights you have and what limitations may exist as to what you might be able to do with that property. Can I hire a trust litigation attorney to stop a partition action? You can hire a trust litigation attorney to litigate a partition action. Your attorney may fight to increase the value of your share of the property if, for example, you paid for maintenance, repairs, improvements, property taxes, mortgage payments, etc. However, the reality is that the property is likely going to need to be sold. And when this happens, instead of everyone receiving their relative share of the proceeds, you'll get what's left after the real estate agent, costs, and attorney's fees. Remember that the party who initiated the partition action, their attorney's fees and costs get paid off the top. So it's extremely important to be the first to act. If you anticipate a partition action may be needed, you should contact counsel immediately. If you have questions, give us a call anytime. The consultation is always free. Partition actions in California law. California law is very clear regarding partition actions. Take a look at California Code of Civil Procedure section 872.210. Keep in mind that the laws regarding partition actions are designed to protect co-owners of real estate, allowing them to divest themselves of the property whenever they choose and recoup their fair market value for their share. There are a number of public policy reasons for this, one of the most significant of which is to ensure that property is made productive and maintained. Property that is embroiled in strife and owned by uncooperative co-owners generally is unproductive and tends to fall into disrepair because the owners can't agree on what to do with it. When do I need a partition litigation attorney? You should consider a partition litigation attorney to examine whether a partition action is needed anytime you feel that you cannot co-manage a property with a fellow owner. Often, by just initiating a partition action, you can force an uncooperative owner to the negotiation table where a deal can be struck, ending the litigation, ending the legal spend, and getting you a result. Do I need a partition litigation attorney near me? We recommend finding an experienced partition litigation attorney familiar with the county courts where the real estate is located. For example, if the property is in Los Angeles, we recommend working with a partition litigation attorney in Los Angeles. That lawyer will be more familiar with the Los Angeles courts than an out-of-state or out-of-area attorney. At RMO, we protect people like you every day. Call us anytime or email us at hello@rmolawyers.com. Thanks for watching.